Welcome to Middle Class Matters, Business News in English from Dr CMA Alagesan. Securities Exchange Board of India's confirmatory order in respect of Subash Chandra, the chairman, Punit Goenka, the managing director, in the matter of ZEE Entertainment Enterprises Limited, Part 15 continued. The primary function and duty of the board is to protect the interest of the investors in securities and to regulate the securities market. The preamble to the Act, which declares the dominant purpose, also makes it clear that the board has been established for this purpose. This duty is performed under Section 11 and 11B of the Act, which are the very soul and heart of it. These two sections are the very reason for the existence of the board. As already observed, Section 11 is very heart and soul of the Act. This provision has been periodically amended and today it is substantially different from what it was at its inception in the year 1992. The scope of the power has been considerably widened. The introduction of Section 4 in Section 11 and various other provisions like Section 11B is indicative of the legislative intent. These provisions are meant to arm the board with authority so as to be able to effectively exercise power and achieve the declared objectives of the Act. It is clear that a common thread runs through the various provisions of the Act, and that is to empower the board to take preventive as well as punitive measures so as to protect the investor and to promote the securities market. From the above findings of the Honorable SAT, it can be discerned that Section 11.1, 11.4 and 11B of SEBI Act are enabling provisions which have been enacted to empower SEBI to achieve its primary objective. Such enabling provisions must be construed so as to serve the purpose for which they were enacted. Hence, all the three sections have to be read harmoniously to advance the object for which SEBI as a market regulator came into existence, rather than adapting an interpretation that would preclude the possibility of the regulator exercising its power to remedy a mischief in a multifaceted and dynamic domain. 65. In the above background, which discusses the measures that SEBI can take under Section 11.1, 11.4 and 11B1 of SEBI Act, I now proceed to examine the submissions of the entities. 66. In the given facts and circumstances of the matter, it was considered in the interim order that the apt measures would be if the entity number 1, who was at the helm of the affairs of ZEE Limited for a significant period of time, and entity number 2, who is the only executive director of ZEE Limited, be kept away from the affairs of ZEE Limited till further orders from SEBI, pending outcome of the ongoing investigation. Such measures was taken under the provisions of Section 11.1, 11.4 and 11B1 of the SEBI Act and not under any provisions of the Companies Act 2013. It is a well settled position that the directions under Section 11 and 11B of SEBI Act can be issued to any person associated with the securities market, including any key managerial personnel or board members of a listed company. Therefore, to submit that considering SEBI's power under Companies Act 2013 is well defined and limited to few aspects of a listed company, SEBI cannot issue directions against key managerial personnel or a director of a listed company would be erroneous. There have been a multitude of cases why ZEE Organization vs SEBI decided on June 29, 2011, Persoli Corporation vs SEBI decided on August 8, 2011, Mr. Girish Chandra Mugundraman Baluni vs SEBI and other connected appeals decided on July 17, 2022, etc., wherein Honorable SAT had upheld the orders of SEBI, where SEBI had directed individuals or directors to be not associated with any listed company. In any case, I note that it was never SEBI's case that the directions have been issued under the provisions of Companies Act 2013. The directions against the entities were issued under SEBI Act, as they are the persons who are or were associated with the securities market in their capacity of individuals who were at the helm of affairs of ZEE Limited and or were part of its management, and there is a prima facie finding of violation of provisions of security laws against them. 67. Further, the submission of the entities that SEBI, not being a court or tribunal under Companies Act 2013, does not have the power to direct any person to be a director, is devoid of merit. Entities are attempting to equate the conditions which can disqualify a person to be appointed as a director of a company with enforcement measures taken by SEBI in the instant matter to restrain the entities inter alia from being part of a listed company when prima facie certain violations have been noted against them under the securities laws. To state that they are one and the same thing is a flawed reading of the relevant provisions of the SEBI Act and the Companies Act 2013. Disqualification for appointment as a director of any company goes to the root of the eligibility and attributes of an individual to qualify to be a member of any board of management of the company, whereas a temporary restraint, as in the instant matter, to serve as a director of any listed company neither disqualifies the individual to become a director in any unlisted or private company, nor does it give a verdict that henceforth that individual can never be appointed as a director in any listed company. In other words, temporary restraint on an individual to be a director of listed companies does not question whether the individual is eligible to be appointed on the board of management of a listed company. It is a specific measure taken by SEBI to keep the particular individual away from the listed companies, as there are findings against the individual which show prima facie violation of securities laws, and the said restraint serves to protect the interest of the investors and to protect the integrity of the securities market. 68. In view of the above discussion, it is clear that SEBI has in the past issued directions restraining entities from being associated with listed companies as directors or key managerial personnel, and the same have also been consistently upheld by Honorable SAT. If the submission of the entities is accepted, the same would lead to a situation wherein the power that can be exercised by SEBI while passing final orders cannot be exercised as an interim measure. To put it differently, what the entities are submitting is that the power of SEBI to restrain an individual from being part of a listed company does not flow from the provisions of the SEBI Act, but it is contingent on the stage of proceedings, which in my view is an erroneous understanding of the provisions of the SEBI Act. 69. Regarding SEBI not having power under section 11.4 to restrain any person from acting as a director, I have already discussed in preceding paragraphs that sections 11.1, 11.4 and 11b1 of the SEBI Act have to be harmoniously read, and the aforesaid enabling provisions together confer powers upon SEBI of wide amplitude to take any measure that would serve the primary objective of protecting the interest of investors and that would promote development of and regulation of the securities market. I do not agree with the narrow interpretation of 11.4 of SEBI Act submitted by the entities, as it is not only an isolated reading of the said provision, but is also against the object of the SEBI Act as laid down in its preamble. 70. Entity number 2 has submitted that he has taken remedial and preventive steps to ensure that no misappropriation of assets of ZEE Limited would take place in future, and therefore the direction issued in the interim order is punitive in nature and which is beyond the scope of Section 11B of SEBI Act. In this regard, I find it relevant to draw reference to the findings highlighting the inadequacy and inappropriateness of the measures taken by entity number 2 to address the issues that have been highlighted in the interim order. Further, I also note that the interim measures taken by SEBI in the present case are punitive in nature, elaborated in subsequent paragraphs, as the interest of entities are factually in direct conflict with the interest of the public shareholders and the company, and the interim measure is aimed at ensuring that a fair and transparent investigation is conducted in respect of the financials of ZEE Limited so that the interest of public shareholders and ZEE Limited are not adversely affected. 71. One cannot lose sight of the fact that SEBI has been vested with statutory powers to regulate the securities market, and regulating the securities market includes regulation through prohibitory as well as mandatory orders, with the objective of ensuring investors' protection and to promote the development of the securities market. Here, it will be appropriate to refer to the provisions of Section 11 and Section 11B of the SEBI Act. A plain reading of the language of the sections itself shows that SEBI has to protect the interest of the investors in securities and has to regulate the securities market by such measures as it thinks fit, and such measures may be for any or all of the matters provided in subsection 2 of section 11, and in due discharge of this duty cast upon SEBI as a part of its statutory function, it has been vested with the powers to issue directions under section 11B as held in Bank of Baroda Limited versus SEBI 2006. Honorable SAT section 11 and section 11B are interconnected and coextensive, as both these sections are mainly focused on investor protection. At this juncture, it would also be relevant to quote the order of Honorable Bombay High Court in a matter of Anand Rathi and others versus SEBI, decided on May 2, 2001, to stress upon the scope and ambit of SEBI's jurisdiction. Honorable Bombay High Court in the said matter held as follows: while considering the question as to whether the SEBI has authority of law under section 11 and 11B to order interim suspension, we have to bear in mind that SEBI is invested with statutory powers to regulate securities market with the object of ensuring investors' protection, orderly and healthy growth of securities market so as to make SEBI's control over the capital market to be effective and meaningful. It cannot be gainsaid that SEBI has to regulate speculative market, and in case of speculative market, varied situations may arise, and looking into the exigencies and requirements, it has been entrusted with the duty and functions to take such measures as it thinks fit. Section 11B is an enabling provision enacted to empower the SEBI board to regulate securities market in order to protect the interest of the investors. Such an enabling provision must be construed as to subserve the purposes for which it has been enacted. It is well settled the principle of statutory construction that it is the duty of the court to further Parliament's aim of providing of a remedy for the mischief against which enactment is directed, and the court should prefer construction which will suppress the mischief and advance remedy and avoid evasions for the continuance of the mischiefs. 72. In the light of the aforesaid legal position and the orders of the Honorable Bombay High Court and SAT, one has to examine the nature of the interim directions issued against the entities. Please like the video, subscribe to the channel. Please share it to as many educated people as possible who are investors in the securities market, so that people will be aware of what type of irregularities are being conducted by the companies, and we can be very watchful about our investments. Thanks for watching.